Okay.
Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 21-1167 et al. The Nasdaq Stock Market LLC et al. Petitioners versus Securities and Exchange Commission. Mr. Hungar for the petitioners, Ms. Hardin for the respondent.
Mr. Hungar, good morning.
Good morning, Your Honor, and may it please the court. Congress was very specific in defining the authority granted to the Commission under Section 11A, A3B. It specified who the Commission can direct to act, self-regulatory organizations, how it can direct them to act jointly, what they can act jointly about, operating the national market system, and why SROs are the congressionally chosen recipients of this responsibility, namely, because it involves matters as to which they share authority under the Exchange Act. Non-SROs are not mentioned because they're not included. They don't share authority under the Exchange Act, and so they have no place in this very specific statutory regime for those who do. And just to drive home the point, Congress also specified the very different role that it allocated to non-SROs. And what is that role? Advisory, as Congress said in sections 11A, A3A, and 11A, D. Given this carefully calibrated and very specific statutory regime, there's simply no silence or gap for the agency to fill. When Congress authorized the Commission to direct self-regulatory organizations to act jointly, it meant self-regulatory organizations, not anyone else with whom the Commission might prefer to share the quasi-regulatory authority that Congress gave only to the SROs. This court has repeatedly rejected similar overreaches by agencies in keeping with the expressio unius canon and the principle that when Congress vests an agency with a specific grant of authority, the agency can't infer a broader general grant from the absence of an explicit prohibition. The same is true here. And the order also does violence to the structure and purpose of the Act because it grants national market system operating authority to individuals who, unlike the SROs, have no shared authority under the Act and are therefore not subject to the SRO's statutory obligations to protect investors and the public interest. Nor are they subject to the Commission's direct regulatory oversight and control the way the SROs are. It begs credulity to suggest that Congress intended to allow non-SROs to exercise this authority without having imposed on them the same regulatory obligations and regulatory oversight that applies to the SROs.
Can I ask you a question regarding, I guess it's section 11A. Let me just give the US code site because I always mess it up when I try to do it the other way. It's 78S, subparagraph C, regarding amendment by the Commission of Rules of Self-Regulatory Organizations. I don't know if you are familiar with that statutory provision or have it handy, but it says that the Commission may abrogate, add to, or delete or amend essentially the rules of an SRO as the Commission deems necessary or appropriate to ensure the fair administration of the SRO and also to conform its rules to requirements of this chapter, et cetera, et cetera. So let's suppose I agree with for the sake of this question, with your contention that only an SRO can administer the national market system. That might implicate the part of the challenged order that would permit a non-SRO to administer the CT data plan. But with respect to governance, why doesn't this statutory provision that I've mentioned give the commission authority to the extent that it deems it appropriate to involve a non-SRO in the governance of this aspect of an SRO's duties?
A couple of responses, Your Honor. First of all, the commission did not cite section section 19 of the Exchange Act 78S C as authority for what it did here. And of course, under TREA, the commission's rule or order can't be defended on a ground it didn't rely on. But more fundamentally, that rule, that statute would have no application here because we're not talking about SRO rules. We're talking about joint action by the SROs, which by definition doesn't involve their own rules. It involves them coming together. That's the point of the plan and the operating committee, is that it's separate and distinct from their own rules because it involves joint authority, which unless the commission approves the plan and authorizes them to proceed jointly, they can't do. And so these are the plan provisions are not individual SRO rules. They're separate requirements created by the commission's authority under Rule 608, I believe, of the national of the commission's rules. And so this provision I don't think would have any application even if the commission had cited it, which it didn't. And then fundamentally, and going back to my primary point, the Section 11A A3B is the only place in the Exchange Act where the commission is given the authority to direct anyone to act jointly. And it's a very specific authority, and it's one that the commission relied on here. And of course, it only involves the SROs in the exercise of their shared authority, and therefore it can't apply to the non-SROs.
Thank you. I thought that I saw that statute cited and relied on, but I take your point. Another provision that I wanted to ask you about, which is in, I guess, Section 11A. It's the provisions regarding the National Market Advisory Board at subsection D. It seems to me that one way of reading this is that if you look at D2, it says that it shall be the responsibility of the advisory board to furnish its views on regulatory proposals made by the commission or any SRO concerning the establishment, operation, and regulation of the markets for securities. And then if you go to D3B, it says that the advisory board shall study whether there's the need for the establishment of a new SRO to administer the national market system, and if so, to recommend how this new SRO will, what relationship it will have to existing SROs. It seems to me that those provisions also strengthen your argument that only an SRO can administer these duties. But I didn't see that argument in your brief, and so I'm trying to understand, perhaps I missed it, whether I'm missing something.
We agree, Your Honor. I believe we did argue, maybe we didn't get down into the quite as granular as your question suggests, but we certainly argue in our brief and today that, among other provisions, 11A subsection D and the advisory nature of that role assigned to non-SROs confirms that Congress, it's not as if Congress didn't think about what non-SROs should do in connection with the national market system. It did, and it thought about them making advisory contributions, including under 11A D3C. the advisory board shall consult with self-regulatory organizations. So there's an advisory role for non-SROs. It's just not exercising authority under the Act role, which is what the commission has improperly tried to delegate to these individuals who aren't subject to the obligations that the SROs have under the Exchange Act and don't share the authority that the SROs have under the Exchange Act.
I mean, this provision contemplates that if necessary, that a new SRO could be created that could be independent of the existing SROs to perform this function, right?
I see your point. Yes, yes, I agree with you. That's a great point, and I agree. That's still further confirmation of the point that there are many mechanisms. I mean, another mechanism available to the commission under Section 11A A3C is it specifically encourages the commission to make recommendations to Congress if they think something about the existing statutory regime doesn't work, given the way the markets have developed. But they can't just depart from the authorities that Congress gave them without going back to Congress for new authority.
Mr. Hunger, I have. Oh,
no, go ahead.
Wilkins, are you okay? I have two questions about the first one about the independent administrator. Are there any SROs that don't sell the proprietary data products and are also affiliated with another SRO that does sell those? In other words, could an SRO be the independent administrator? I don't think so.
Please, Your Honor, I'm not entirely sure about this, but I know it has been the case, and I believe it is still the case that there is at least one, if not more, SROs exchanges that do not sell proprietary data, but I can't be entirely certain about that. And so if that's the case, which I believe has been the case, and I think probably still is the case, then such an SRO could qualify as the independent administrator. The problem is there are only two administrators right now that have experience with this, and both of them are affiliated with exchanges that do sell proprietary data. So the exchanges that have the administrators that have all the experience and expertise are precluded by the commission's rule, which is what results in the imposition of the very substantial costs that the independent administrator requirement will impose on the markets.
Right. And then the other question I have is the difference between 11A and the regulation in the language. Let's see here. It's A3B. It's the language we're talking about. By rule or order to authorize or require self-regulatory organizations. Then you get to the reg and it drops required. And it simply says in 3, and I'm looking at 608A3, self-regulatory organizations are authorized to act jointly, and they lop off required. Should we read anything into that? Just out of that discrepancy?
I don't think so, Your Honor. I mean, obviously, the statute allows the commission to authorize or require, or both. Here, they chose to authorize. I mean, I think as a practical matter, if you're a self-regulatory organization subject to the commission's oversight and control, and the commission has developed a national market system and authorized you to play your role in participating in it, it's something of a directive, even if phrased as an authorization. But I don't know that it makes any difference as a statutory matter. I mean, the point, from our perspective, the point about Rule 608 that's most important is the fact that it simply confirms and drives home the fact that only the SROs are authorized to act jointly. The Rule 608 is filled with references to the SROs and the plan sponsors, which is simply SROs under another name, and the roles that they play exclusively, with no reference whatsoever to any role being played or allowed to be played by the non-SROs in the governance of the plans. I see that my time is.
You don't see that lack of the phrase or required to in any way would allow the SROs to say, well, we are authorized, but we're not going to do it. In other words, there's a difference between being authorized and being required to.
I mean, so Your Honor, with respect to the plan, so the commission ordered the SROs to develop the CT plan at issue here and to propose it to the commission. And then the CT plan, if it is not set aside, which it should be, has directives and mandates and requirements for how the exchanges are to operate. So I think it's a practical matter, and given the other obligations of Reg NMS and the obligations of the SROs to provide data to the SIPs and to operate the SIPs and to provide the that information to the market, I think it's a practical matter, though, although framed as an authorization, it really works as a requirement.
Right. Okay.
I have
okay.
just a couple follow-up questions.
Sure.
So under the statutory scheme, the securities information processor is defined in the statute, but it is not defined to be an SRO. Am I correct about that?
Correct. Yes, the securities information processors, there are two of them, and they're not SROs, but they are affiliates of the NYSE and the Nasdaq, respectively.
So they're not bound by the National Market System Plan or anti-fraud provisions, etc., just like broker-dealers or other non-SROs aren't bound by those. Am I correct about that?
I don't know. I mean, there are provisions, confidentiality provisions, conflict of interest provisions, a variety of provisions in the plan, and as affiliates of SROs, the obligations under the Exchange Act apply to SROs and their members and affiliates. So I believe, and certainly there are extensive obligations in the plans and in Reg NMS regarding how SIPs, securities information processors, are to behave, and so they are subject to all those requirements. I can't cite you chapter and verse for those requirements, but SIPs are clearly regulated entities expressly covered by numerous provisions of the regulations and the plans.
Thank you.
All right, Mr. Hunger, we'll give you a couple of minutes in reply. Ms. Harden, good morning.
Good morning, Your Honor, and may it please the court. I'm Tracy Harden on behalf of the Securities and Exchange Commission. I think, as became clear in the arguments this morning, the flaw in petitioner's challenge here is that they're misreading this particular subsection to perform a purpose that's just not the work it's doing. They're improperly reading that section in isolation, and it becomes clear when you look at the entirety of section 11A that the work A3B is doing here is, as Mr. Hunger said, making clear the ability for SROs to act jointly when they otherwise couldn't, because
now, you understand that as a statutorily created agency, your agency has only those authorities given by Congress. What's your best statutory language that says the commission can do what they're doing here with respect to the acting jointly requirement?
Your Honor, I think the operative provision is 11AC, which is the provision which grants the commission authority and requires the commission to develop a regulatory system for the dissemination of market data. And as the commission explained, in the proposing order, in the governance order, and in this order, the equity data plans we're talking about here were created to fulfill the obligations under 11 Cap A-C. And that provision expressly contemplates the involvement of other market participants in the dissemination of market data by funneling them through the regulatory system Congress directed the commission to set up. And actually the Senate report makes clear that these provisions were intended to bring within the commission's statutory jurisdiction any entity involved in the collection, processing, or publishing of market data. And so I think, and even A3B, which the petitioners are relying on here, necessarily requires resort to other statutory provisions, right? Of course, it has to further the purposes of the directive in 11A. It expressly refers you back to there, which talks about the commission using its authority under the entirety of the Exchange Act. There'd be no reason to say that if Congress intended A3B to be the only authority.
What do you see as the office of the acting jointly language? What's it in there for if petitioners are not correct that it was needed in order to allow them to act jointly, and that without it, you don't have any authority to deal with acting jointly? That is to say, where it doesn't apply.
Your Honor, the work it's doing is to allay antitrust concerns that otherwise would exist if SROs were to act jointly. And remember, right, the provision is not just talking about administration of the national market system as a whole. It talks about regulation, administration, or operation of any subsystem or facility thereof. The system Congress was setting up in 1975 was a system in which individual competing enterprises were to have to come together, act cooperatively, and sell a product on a mutually agreed upon price. That creates obvious antitrust concerns. And in fact, the legislative history indicates Congress was worried about that. And the antitrust implications of exchange actions were, in fact, the subject of conversation in the courts at the time after the Gordon and Silver cases in the Supreme Court. And so the work that is doing is clarifying the availability of that tool in the development of the market system, but it doesn't specify, right, the particular subsystem or facility of the national market system that joint action is with respect to. For that, you necessarily have to look to provisions in the regulatory scheme which govern the substance of that.
Absent that language, and I think I hear you just lurking in the background of what you're saying, would the SROs have a fear or danger of being in violation of antitrust provisions if they acted jointly?
Absolutely, Your Honor. And certainly at the time the act was passed in 1975, that was very much an open question. There have been some developments in antitrust law that may allow them to have sort of a stronger argument for an implied waiver of antitrust under the Exchange Act, but that wasn't the case in 1975. And certainly there's specific discussion in the House hearings leading up to this bill about the need for this kind of provision.
Is there any problem with respect to the non-SROs in that area today, as to say, if they're acting jointly with the SROs, is there any danger of accusation of antitrust violation on the part of those entities?
I think there are factual and legal distinctions between sort of the participation of non-SROs on. And again, we're talking about representatives of varying categories of non-SROs. Unlike the exchanges, right? You're not talking about every broker dealer being a member of this operating committee, right? You're talking about two representing different categories. Whereas the exchanges, in order for a consolidated data feed to exist, you necessarily need all of the exchanges. I do want to sort of address kind of one argument in this respect that the petitioners raised in their brief, which is if Congress was worried about antitrust and contemplated other market participants, why wouldn't they be listed in A3B? And I think the answer to that question is very similar to what we've just been talking about, Your Honor, which is there was less legal or factual clarity that was a risk with respect to non-SROs, and there wasn't sort of a particular highlighted concern that was already sort of being discussed in the legislative history and in case law at the time. So I don't think that precludes our reading. And I do think once you sort of recognize that A3B is serving that role and that it itself is indeterminate about the substance of the market facility we're talking about, you necessarily have to look to surrounding provisions, including 11 Cap AC, which is specific to the market activity we're talking about here, right? Congress very specifically directed the commission to create a regulatory system to assure the prompt, accurate, reliable, and fair collection, processing, and dissemination of market data. As the commission said in this order, given changes in the market, it is no longer clear that these equity data plans, which were created to serve those purposes, are effectively doing so. And so that is why the commission stepped in here and made what is a measured change. And I want to.
So why then did Congress, in setting forth the duties of the National Market Advisory Board, speak only in terms of administration by SROs and proposed plans by SROs? And if there is a need to kind of have a new administrator, then it should be an SRO.
So I think a couple of things, Your Honor. I do want to point out, just as an aside, that provision actually, Mr. Hungar said that SROs are consulted by that board, but that provision also lists non-SROs being consulted by that board as entities that are interested in or likely to participate in the establishment, operation, or regulation of the national market system. It lists broker-dealers, it lists SIPs, and it lists issuers and investors. So again, this is specific. But
that doesn't help you because it says interested in.
Your Honor,
So all of those non-SRO entities can be interested in, but it doesn't mean that Congress contemplated that they would take a role in establishing or administering.
A couple of things, Your Honor. First, I would say, we're not arguing that the statute is clear at Chevron 1. What we're arguing is that there is ambiguity as to whether Congress would have.
But here's why I'm concerned that it's not ambiguous, and it's not ambiguous against you, because if you look at the National Market Advisory Board language at D3B, it says that the advisory board shall study the possible need for modifications of the scheme of self-regulation provided for in this chapter so as to adapt it to a national market system, including the need for the establishment of a new self-regulatory organization to administer the national market system. That's very explicit language.
So, Your Honor, I think what that shows, right, is in the 75 amendments, Congress very specifically did not make a decision as to the precise manner in which the national market system was going to be structured, right? This is something new in which it's asking existing industry players to come together and engage in this joint enterprise. Congress considered a number of different options, right? Which is it being administered by some combination of the existing exchanges, broker-dealers, other market participants, creating a new entity to administer it, which would be this new self-regulatory organization that the advisory board looks to. But ultimately, Congress said, look, Commission, here are your very specific goals. Here's the things your regulatory system has to advance. Within that sort of ballpark, you can't stray outside the ballpark, but within that ballpark, we're going to leave the operative decisions to you. One option on the table is creating this new kind of entity, right? This SRO. But the very fact that this is set up for an advisory board to look at and consider doesn't show that Congress wasn't saying this is the right way to go. And ultimately, the
But why
advisory
would Congress have that as the only option for the advisory board to consider unless Congress believed that it should be an SRO to administer this system?
because the other options are already embodied elsewhere in the statute, Your Honor, which is the
If
other
they're-
options.
Where are they embodied in the statute? Because you mentioned subsection C, but I think that the problem that you run into with it is that it mentions non-SROs, but it also governs purchases and sales and other things beyond the dissemination and publication of market data. In provision C1E, for instance, it says brokers and dealers have to essentially input the data pursuant to the rules of the national market system, because obviously the system can't work unless all of the people kind of using it in bidding and making offers input the data. So I don't really see how this particular subsection contemplates that Congress shows that Congress contemplated a non-SRO to administer the system.
So I think there's two things, right? One, I would point out that A3B itself is not just about administration. Again, it encompasses operation of facilities and subsystems. And so for petitioners to be correct about their reading, Congress, in the context of being concerned about market center domination of market data, solved that problem by codifying SRO control down to the operation of facilities and subsystems to the exclusion of all others. I think that's a pretty unlikely reading of that language. But to turn to your question about paragraph C, right, what this provision does is it funnels all of these entities listed sort of at the beginning of C1 through all of the rules listed that it directs the commission to promulgate, right? And one set of those rules is to assure the prompt, accurate, reliable, and fair collection, processing, distribution, and publication of information with respect to market securities. And again, reading this in juxtaposed against A3B, which again has a clear alternative role to play here, I just don't think you get to clearly precluding other market participants. And the commission's read of this is perfectly reasonable when you look to not only the language, which indicates some contemplation, right, that other market participants would be involved, not only in C, but in Congress's findings and objectives for A1, but also if you look to the legislative history and the purpose of this statute, right? Congress or the Senate report explicitly says, we intend to bring all entities involved in the dissemination of market data into the commission's regulatory jurisdiction. And we want to create a system that ensures the fair dissemination of this data, which in a consolidated form is essentially a monopoly. And we need that to work for other market participants. And we are concerned that that data is currently being dominated by market centers. Right? Given that purpose and history, the petitioners would have you believe that Congress codified for all time their exclusive control over all facilities and mechanisms of the national market system. And that's at the very least not clear, given the indications in the text.
Well, Congress contemplated that a new SRO that could be independent of any of those SROs could take over the responsibility, right?
Congress contemplated, as I said, a number of options. It could have been the exclusive SRO control they're talking about. It could have been joint activity between the SROs and non-SROs as the commission encompassed in this order, or it could have been a new body altogether, a new SRO. But what Congress did was say, markets are dynamic, markets are ever changing. We are going to give the commission the tools to watch how the market develops and nudge it in the direction to develop to hit our findings and objectives, right? This isn't a situation in which the commission is charging in guns blazing, sort of upending the system. This is a measured change, an incremental change from what was established in 2005 when these market participants were given an advisory role on the operating committee of the NMS plan, right? The move here is from an advisory role to a minority voting power. And that is justified by the sort of fundamental changes that have occurred in the market, most specifically, right, the shift of these exchanges that currently dominate the national market system plan from nonprofit mutual organizations to for-profit companies that sell a competing product, and the consolidation of a number of the exchanges into these large exchange groups that then can dominate voting control in the operating committee. And what the commission reasonably determined is that the combination of those factors and sort of the conflict of interest that exists because they sell these competing products necessitated at least a little more weight behind the vote of the advisory committee members. And that's really all we're talking about here. It's a very reasonable, appropriate reaction within the bounds of the statute and the system Congress created.
I mean, I could agree with all of the kind of factual basis, and I don't even think that there's much of a dispute about the factual basis that some of these other data systems are faster than the systems disseminating the core data and the conflict of interest, et cetera, and may agree as a policy matter that what the commission, is doing kind of makes perfect sense and is reasonable in that regard. That's separate from whether the statute permits it. I mean, you're essentially saying that even though Congress explicitly created an advisory role, we can read between the lines and say that Congress authorized us to make these parties who had an advisory role actually have a governing role.
So, Your Honor,
and the best language you have for that is kind of the absence of exclusive in subsection A, and this language in subsection C that encompasses kind of all parties kind of involved in the system.
So, Your Honor, I do want to make clear one distinction between the advisory roles that are talked about in the statute and what we're discussing here with respect to the operating committee on an NMS plan, right? The advisory role in this statute is about the market structure writ large, and it's advice to the commission about market structure writ large. That's true both in D and in the other subparagraph the petitioners point to, which is A3A, I believe, which talks about advisory committees under the Federal Advisory Committee Act, right? We're talking about advice to the commission about larger market structure issues. What we're talking about with respect to the operating committee of a national market system plan is a body that's making the day-to-day decisions about the operation of the consolidated data feed, right? Where those provisions don't talk about who is making decisions about the day-to-day operation of the feed. And that's what the operating committee is doing here, right? It's essentially sort of like a board of directors. And you can
I understand that. I'm just trying to make sure let me make sure I understand your current argument. You're saying to me that the National Markets Advisory Board is not authorized to speak to this issue. Is that your argument?
I'm saying that wasn't the purpose of that board, right? The purpose of that.
Can that board, if it wants to, make a recommendation to create a new SRO to perform the functions of the CT board?
So that board doesn't exist anymore, right? It is a board that was created by the 75 Act to make recommendations. It made recommendations, and it has long since disbanded. So there are, equity markets advisory committees that the commission has created under the Federal Advisory Committee Act. And that advisory committee actually explicitly recommended and supported governance reforms almost exactly like the ones the commission made in this order. And so to the extent there's a question about what those advisory committees believe is important, the one that currently exists recommended these changes.
But doesn't this, unless I'm misreading this, which I may be, but doesn't Section 11A have provision about creating other advisory boards other than this particular National Market Advisory Board?
That's what I'm talking about, Your Honor. If you look at paragraph A3A, just above sort of the subparagraph we've been talking about here, it allows the commission to create advisory committees under the Federal Advisory Committee Act. And there is a equity market structure advisory committee that the commission convened in 2015 to look at equity market structure issues precisely because of the sort of shifts in the market that prompted this order. And that advisory committee recommended many of these very same changes that the commission made in this order. And it did not believe there was an authority problem with making those changes. So I'm not, and I think, to sort of step back a minute and look at the larger statutory argument, right? The fact that Congress kind of set a floor and made clear that all market participants should be able to provide advice about how to engage in this joint enterprise doesn't mean that Congress has precluded more roles. I think, that's evidenced by the fact that, as Mr. Hunger said, right, the statute even contemplates a consulting role for SROs with respect to the advisory board. So just because Congress envisioned everybody involved in this having a say doesn't mean it precluded formalizing that say by votes on the operating committee of a national market system plan, which, by the way, isn't even mentioned in the statute, right? These plans grew up as a way for market participants to jointly comply with regulatory obligations based on other provisions in the Act, right? The CQ plan, one of these data plans, arose as a industry way of jointly complying with obligations under a market data rule that the commission promulgated under paragraph C here. So I think that
I have a question regarding the independent administrator. Let's suppose it is an entity that is not an SRO. What rules and statutory provisions are going to apply to it?
So I think first to sort of go back and clarify what the plan requires, which is that the administrator not be affiliated with an entity that sells proprietary data products. And so to sort of circle back to Judge Henderson's question from earlier, right, there are SROs that don't sell proprietary data products right now. There are some independent exchanges. Of course, FINRA is an SRO and a participant in the plan. But to get to Your Honor's point in terms of what binds the administrator, as is currently true, right? The provisions of the plan govern the administrator's actions. Those include conflicts and confidentiality provisions, but they also include sort of the policies and procedures of the plan. And there's a few other sort of fail safes there, right? Which is Rule 608 and Rule 608D allows the commission to hear appeals from the action or failure to act of anyone in connection with a national market system plan. And so anyone can bring a claim to the commission under that provision, and there's an adjudication where the commission looks at whether the action or failure to act was consistent with the terms of the plan and whether the terms of the plan are being applied consistent with public interest, protection of investors, fair and orderly markets, sort of all the regular standards. So that process exists. And then, of course, there's sort of the fundamental point that the SROs here maintain majority voting control, a supermajority voting control on the operating committee. So they can control or preclude any action that by either the administrator or non-SRO members of the operating committee that they don't believe is consistent with the plan or other regulatory obligations. And finally, of course, plan action runs through the commission for approval, and it examines for consistency with the act, the plan, and other regulations. I know my time is
All right,
long.
Judge Wilkins, have you had your questions
I don't
answered?
have any further questions. Thank you.
All right, Judge Sentelle. All right, I do have one for you, Ms. Harden, and that is, let's assume that we think the addition of the non-SROs to this CT plan operating committee is ultra vires. Your argument about severability is pretty sparse, and I don't want to lengthen the argument any more than we've already done, but you do speak about the second requirement we're supposed to look at. That is that the agency, you say it can function sensibly, and that's more or less a parroting of it. But we've all listened to your expansive description of how the SEC wanted to open this whole thing up, and including the non-SROs, which was very important. So without those, I don't see that the first requirement, that is, did the agency intend, intend to pass the legislation even without the non-SROs? I don't see how you can argue that it did in light of what you've already argued about its intent to expand participation. But if you want to take a minute or two to respond.
Yes, Your Honor, and I will try to be brief, right? We have talked at length about the non-SRO requirement this morning because that's been sort of the heart of the petitioner challenge. The order itself and the governance order which preceded this also speak at length about the benefits of the exchange group voting allocation and the independent administrator. The logic of both of those provisions applies sort of irrespective of whether there are non-SRO members on the operating committee. I will say with respect to the sort of augmented majority voting structure that is set up under the plan, that may be a situation in which a remand would be appropriate. We would argue a remand without vacatur if the non-SRO participants are not on the operating committee, just because of the way sort of the wording of the plan sort of envisions there being non-SRO members. But I also want to point out that there's a number of parts of this plan that aren't challenged at all. Right. Another sort of innovation in this plan is the combination of the existing 3 equity data plans into one. None of that is implicated by the logic. And so we would argue that, there is severability language in the order, there is severability language in the plan. The logic of these 3 things are separate. Beyond that, the logic of the other provisions of the plan are not implicated here. And so we think, this may be the rare case in which remand without vacatur is appropriate if what the court is doing is vindicating only
Right.
a subset of petitioners' challenges.
All right, thank you. Mr. Hunger, why don't you take 2 minutes?
Thank you, Your Honor. 4 brief points. Taking severability first. In addition to the fact that this non-SRO voting mandate was a core goal of the commission, and therefore, if it is invalidated as it should be, vacator is required. It's simply not the case that the regime can function sensibly if that's invalidated, because it becomes internally inconsistent. There are 2 different voting requirements for the operating committee's decisions, a majority vote requirement and a 2/3 vote requirement, and there'd be no way to know which one governs once you throw the non-SROs out. The operating committee couldn't even just do anything, that the plan would have no leadership because it would be incapable of deciding even how to make decisions. So for that reason as well, vacator would be required, even if only the non-SRO voting requirement is invalidated. And for all the reasons stated in our brief, the vote dilution provision is equally invalid. Second, counsel for the SEC argues that the operative provision here is section 11A-C. The commission did not even rely on 11A-C as authority for the acting jointly mandate. It relied on 11A-A3B, and that's because 11A-A3B is the only statutory provision that talks about acting jointly. 11A-C doesn't say anything about conferring authority on anyone to exercise regulatory authority, let alone on non-SROs. It talks about imposing mandates on the regulated community by the SEC through rules. So yes, non-SROs are obligated to comply with regulations promulgated by the commission to the extent they apply to non-SROs. That hardly suggests that Congress intended to give the commission the authority to delegate SRO authority to non-SROs, where nowhere in the Exchange Act are non-SROs entitled to exercise such authority. The antitrust argument advanced by counsel is completely baseless. The only reference to antitrust concerns in the committee reports of the 1975 legislation have to do with the antitrust concerns about a single SRO's rules that could have antitrust implications for people operating in a given exchange. It has nothing to do with acting jointly. There's not a shred of evidence in the legislative history that Congress had any concern about antitrust when it was acting jointly. And
Counsel, suppose we're looking at the language of the statute without looking at the legislative history. Is it not susceptible of the interpretation that by giving them permission to act jointly, this is a protection against possible antitrust liability? Remember, some of us don't look at legislative history very much, but there's not any legislative history. Why isn't that a reasonable possibility to the statute?
It's a possibility. We have no way of knowing. I mean, they certainly didn't say it, but it's a possibility that was one consideration. But it's also simply a logical inference that when Congress has granted authorities to individual SROs, but it hasn't authorized them to act jointly, they don't have the authority to come together and act jointly, regardless of the antitrust laws. And so Congress wanted to provide a mechanism for the commission to let them exercise their regulatory authority jointly, and it created this provision. But there's no reason to infer from that it intended Congress also to be able to do that for non-SROs who have no regulatory authority. And again, the non-SROs if it's true,
where does the statute say that a single SRO can propose a plan?
I'm sorry, Your Honor?
Where, if at all, does it say that a single SRO acting solely can propose a plan?
Well, by definition, plans as devised by the concept of national market system plans is a creation of the commission and its rules. And by definition, a plan is national SROs acting jointly. If you look at Rule 608A, that's what a plan is. And in fact, so it's by definition, if you have a plan, it's because the commission has authorized SROs to act jointly through a plan. But the statute in section 6, that's 19F, and in section 19B authorizes SROs individually to adopt rules and imposes on them various regulatory obligations and grants them various regulatory authorities. So they have the authority to for instance, to adopt rules concerning the dissemination of market information and coordinating the activities of persons involved in that activity individually pertaining to their own market information. The point of section 11A(a)(3)(b) is to give the commission the authority to permit them to act jointly, which the commission did through creating the Rule 608, which allows national market system plans.
So why isn't one way of reading this statute that to be, well, the independent administrator in the CT order has to be an SRO? It can either be an existing one or a newly created one. And so we limit the order in that fashion, but we don't have to set it aside. And to the extent that the commission amended the governance by adding non-SROs to the operating committee, we can interpret the statute to maybe speak clearly as to whether ultimately an SRO has to control that function, but so long as this plan gives SROs essentially the ability to control by having a majority of the votes, it does so and doesn't run afoul then of the statutory scheme.
So I think there are two questions there, Your Honor. With respect to the administrator point, I think your correct observation that section 11A D3B, if I'm getting my letters correctly, provides further evidence of the point that Congress intended the SROs and only the SROs to be involved in administering the national market system and therefore the national market system plans. I think that's an excellent point, a valid point, and a further reason why the commission's independent administrator requirement is invalid. With respect to the second part of your question about non-SRO voting, the statute requires SROs to be able to act jointly. Under the current regime, the commission, by giving voting power and influence to non-SROs who Congress clearly did not intend or authorize to exercise quasi-regulatory authority, has completely upset the regime that only SROs should be exercising this authority. If non-SROs have voting power and significant voting power, given that the SROs don't agree on many issues, that means that the non-SROs have the authority to essentially influence the decision-making, the regulatory decision-making by the SROs. And the whole point of including them in the commission's view is that the commission thinks they will have the ability to change the way decisions are made by the committee. It's like the Supreme Court's decision in Aetna against Lavoie. Even one member of a 3-judge panel let alone a larger panel, has an influence on the decision-making process, and in that sense is exercising authority. And if that person has no right to exercise authority, the whole system needs to be set aside. The decisions cannot stand.
Well,
that's equally true here.
If on this or any other case, I'm with on a panel of 3, and the other 2 judges disagree with me and vote differently. I may have had an opportunity to influence the decision making, and I would have had some input. But ultimately, those 2 judges are going to exercise the authority of the court. I can write a dissent, but as much as I might like that dissent to have some authority, it will have none.
That's true, Your Honor, but in some cases, it might go the other way, and you would be in the 2-to-1 majority. And in that circumstance, your role would very much have been important, indeed dispositive in the decision. And the same is true here. Indeed, that's the intent of the regime. The commission expressly says, yes, the point of this regime is that the non-SROs should be able to join together with a minority of the SROs to make decisions and impose their will on the majority of the SROs. So the commission is intending and envisioning that the non-SROs will play a dispositive role in decision-making that is clearly the exercise of regulatory authority in a way that Congress did not envision. That the commission's reliance on 11A-C simply proves the point, even though the commission in the order didn't rely on it and therefore can't rely on it as a basis for trying to save its order from invalidation. But 11A-C makes clear that the non-SROs are the targets of regulatory authority, not the exercisers of it. And it would be extraordinary to think that an agency can take regulatory authority that's been granted to one set of entities and give it to someone else when Congress determined that the people the agency wants to give that authority to were not to be the people exercising regulatory authority, but the people subject to regulatory authority. It's incongruous. The commission doesn't identify a single case in the history of administrative law where an agency has acted in that way without congressional authorization, and this should not be the first such case.
All right. Any more questions?
No.
All right.
Thank you.
Thank you then. And Madam Clerk, if you would call the next case.
$6289, Committee on Ways and Means, United States House of Representatives versus United States Department of the Treasury et al., Donald J. Trump et al., appellants. Mr. Norris for the appellants, Mr. Letter for the appellee, Committee on Ways and Means, United States House of Representatives, Mr. Sinstadt for the appellees, U.S. Department of Treasury et al.
Mr. Norris, good morning. Please proceed.
Good morning, Judge Henderson. May it please the court. My friend, Mr. Letter, and I have litigated 4 of these cases together. We've litigated whether the House can get President Trump's accounting records, his banking records, his state tax returns, and now his federal tax returns. But none of those other cases were decided on a motion to dismiss. This one shouldn't have been either. The key question in these cases is whether the committee has a legitimate legislative purpose. If we didn't plausibly allege a non-legislative purpose here, then no one ever could. As we thoroughly explained in our pleading, committee members stated non-legislative purposes for obtaining President Trump's tax returns over 150 times. Chairman Neal himself admitted that his stated legislative purpose was a post hoc rationalization made for litigation, and the United States federal government for 2 years formally concluded that his purpose was exposure for the sake of exposure. These allegations would be sufficient.
Counsel, is it not possible that a committee or an actor, or an Article I actor could have a legislative purpose and another purpose? Would that not be possible to have more than one purpose?
That is possible, Judge Sentelle, but we have.
Right, now, does that disenchant their legislative purpose if they have some other purpose? And does that throw out the value of their legislative purpose?
Judge Sentelle, that assumes that we pleaded that they had 2 purposes, but our factual pleadings are that they had 1 purpose.
I understand that. I'm assuming no such thing. I'm saying your pleading may not carry the ball for you because there may be a legislative actor who has 2 purposes. You allegedly have 1. And I'm asking you, why isn't it possible that they have 2?
It's not possible because we've alleged as a factual matter that they have 1, and the government concluded.
Your allegations are not binding on them or anybody else or the court. You allege 1 purpose, but that doesn't mean they don't have 2 purposes, does it?
I think it does. That's a factual allegation that the court has to accept as true at the pleading stage. But Judge Sentelle, even if that was a competing interpretation, you also have to construe everything in our favor at the pleading stage. And
back up a moment. That's not just a factual, that's a mixed question of fact and law about the 2 purposes. And I do not see why the court would be bound by that. We
Well,
would not have to assume the truth of it, would we?
I disagree with that. I think purpose is a factual question, but Judge Sentelle, a couple other answers, if you don't agree with me on that, is we have plausibly alleged that there was only one purpose. It was an illegitimate purpose because that's what the federal government concluded. That's what Chairman Neal said. That's what all of his colleagues said over and over, hundreds of times, both before and after the request was made. But the case law also does somewhat contemplate the situation that you're talking about. Kilbourne versus Thompson, the very first case in this area, asks what the gravamen of the request is. And cases like McGrain and Barenblatt ask, what is the primary purpose? Or was there an illegitimate purpose that was affirmatively avowed? So the case law does contemplate the situation where they may have had two purposes. And it says Congress still loses if one of the affirmatively avowed purposes was illegitimate, or if the illegitimate purpose was driving the ship instead of the legitimate legislative purpose. And that's what we think is happening here, Judge Sentelle. But more importantly, that's pretty standard talk for a legitimate legislative purpose test. But this is not a standard case. Everyone here agrees that the committee's demand for President Trump's tax information.
Counsel, you say that this case shouldn't have been decided on motion to dismiss. How should it have been decided with respect to the question of determining what the legislative purpose was? There's supposed to be some discovery on that. You're supposed to be able to take depositions of the chairman of the House Ways and Means Committee. What procedural irregularity are you complaining about here?
Sure, Judge Wilkins. Well, I was about to mention that this case implicates the separation of powers. So the legislative purpose test is subject to heightened scrutiny, where the Supreme Court has said the committee has to come forward with evidence about what it's doing. So this is a uniquely inappropriate case for a motion to dismiss, but I understand your question. And our right to discovery here is limited because we can't get discovery normally of Congress. They have legislative immunity, but it's not non-existent. And I think Judge Bates's opinion in the Jewish war veterans case explains this exactly right, which is there are things that are not protected by legislative privilege, but that do bear on purpose that we could get our hands on. For example, communications between the executive branch and the committee are not privileged, as Judge Bates explains, and they would shed light on our First Amendment claim, for example, in terms of how much influence did the committee have over the government's decision. It would also bear on what accommodation efforts, if any, were attempted by the government, which speaks to whether this satisfies heightened scrutiny or not. We could also get, our pleading is fairly robust in the number of statements from committee members and Chairman Neal about their purpose, but we don't have them all. We could also get their public statements, which are not protected by legislative privilege. And we could also get what happened. So there was a sit down between the IRS and the committee to explain the presidential audit process. We're not sure the full extent of what the committee already knows about the process based on its communications and accommodation efforts with the executive branch. We could get that in discovery as well, which speaks directly to heightened scrutiny.
The district judge debated between two tests for purposes of this case, the Nixon test, I guess, the Mazur test. What do you understand those two tests to be?
We understand, our position is that this court should apply Mazars. Mazars explains.
Tell me what you understand each of those tests to be, and then come to your position, please.
Sure. Mazars has 4 requirements: that it's a heightened version of the legitimate legislative purpose test for when Congress's demands implicate the separation of powers. It asks, is this request justified by the significant step of involving a president justified, or can you get this information from other sources? It asks whether the request has been specifically articulated and whether it's supported by evidence. It asks whether it's broader than reasonably necessary, and it asks whether it imposes undue burdens on the presidency. And any one of those requirements is violated, the committee loses and can't make the demand. That's Mazars. The Nixon versus GSA test, our position, and I don't mean to question the premise of your question, but our position is that test doesn't possibly make any sense in this context.
State what the test is, your understanding, what you understand the test to be.
The part of Nixon versus GSA that Judge McFadden relied on is the test for when a statute violates Article 2. And the test is you ask how much it intrudes on the presidency, and you weigh that against how much of a congressional interest is at stake. And you weigh Congress versus the president and you balance it out, figure out who wins. But our position is that Nixon versus GSA it's just the Youngstown Steel test. It goes back to Justice Jackson. It's the general test for when you are weighing an Article 2 challenge to a statute. It has nothing to do with the request from Congress. It has nothing to do with the fact that Nixon was a former president. None of that applies. Nixon was making an argument that any citizen can make that the statute there was unconstitutional because it burdened the sitting president's executive power. This case is different. This is a congressional request. The test for congressional requests has always been the legitimate legislative purpose test, and Mazars tells you how to apply that here. And if I could just talk about how to apply Mazars to this case, we think every step of the Mazars test is violated by this request, but I'll say we're at the pleading stage. So what the question is, did we plausibly allege a claim that this request will violate heightened scrutiny? And we think we did for several reasons. This request does not, the committee's stated legislative purpose does not justify the significant step of involving a president. The committee, I think Judge McFadden was exactly right that you have to figure out what type of legislation the committee is allowed to be considering here. So it has to be legislation that this request would tell the committee something about, and that legislation has to be constitutional. The core piece of legislation that the committee has used in this case is that they want to codify the presidential audit program. They want to pass a statute that says the IRS has to regulate or has to audit the president, and here's how they have to do it. But Judge McFadden was exactly right that statute would be unconstitutional. You can't tell subordinates of the executive branch that they have to investigate the head of the executive branch against the executive branch's, against the head's wishes. That's unconstitutional. So what Judge McFadden said is the statutory litmus test here are laws that don't require the IRS to audit presidents, but that just regulate the process by funding the IRS and its ability to regulate presidents, or by increasing the number of staff they have available. But those don't justify a detailed request for specific individual tax returns and audit files of a president. The committee, the presidential audit process itself is already written down in the Internal Revenue Manual. And my friends will tell you, well, some parts of that manual are not followed anymore, but they conveniently never tell you which ones those are, why they matter, if they're significant at all. And the IRS, we know from two declarations that they submitted in this case at docket 44-4 and 44-3, that there was a 3.5-hour briefing between the IRS and the committee telling them exactly what they wanted to know about the contours of the presidential audit program. Now, if that briefing was insufficient, we're never told how it was insufficient, and we're never told why there was not a follow-up request under the Biden administration.
Are you contending that a valid legislative purpose has to be the purpose to pass a bill or to introduce a bill? That it has to be, that it can't be oversight?
It can't be oversight in a vacuum. It has to be to study legislation that would be constitutional if passed. And I say oversight in a vacuum because we know it can't be exposure for the sake of exposure. That's very clear.
No, I'm saying if there is an audit program and Congress, putting aside President Trump's tax returns, Congress issues a request for information, and it's for the purpose of oversight of whether the audit program is operating properly. Would that request be consistent with a valid legislative purpose?
I think Judge Wilkins stated just like you stated it. That's too unclear and non-specific to satisfy heightened scrutiny. The Supreme Court in Mazars said, because this is an elevated test, we want Congress to adequately identify what it's doing with specificity and not use vague and loosely worded explanations. And that's because you're dealing with a president. The committee says we're looking at the president-specific legislation here. President-specific legislation is a constitutional minefield. They need to explain what they're doing so we can assess whether the information will tell them anything relevant and whether the bill they're considering would be constitutional. So I'll give you an example. They claimed that one of the things Judge McFadden said they might be able to legislate is what's the staffing situation for presidential audits. But if my friends are considering a bill that would prevent the president from removing an IRS officer who's auditing his tax returns. That presents a serious constitutional question. The Supreme Court has addressed removal cases a series of times in recent years, but we don't know, stated at that level of generality. The only specificity in this request is that they want to codify the program. And we've explained, Judge McFadden explained why that type of legislation would violate Article 2, and no one defends its constitutionality here. It's all about funding and staffing, and those types of predictive, broad policy judgments just are not enough to involve a president. And if I could give another example, the idea that this is about the IRS's budget is just—
how are they not, you're saying that they're not specific enough to involve a president, but the audit program is specifically directed to presidential tax returns and has been around for 50 years.
Correct. But the question is, what do they want to do about the audit program in some specific sense? I mean, they don't have to have it exactly direct, they don't have to have the text of a draft bill or anything like that, but they've got to give this court a sense of the legislation that they're thinking about and whether it would be constitutional. And when you regulate presidents, you run into all sorts of problems. And so Judge McFadden backed away from that problem and said, well, how about legislation that just funds the IRS? But this is one audit of one president per year. This has nothing to do with the IRS's budget. Just last week, the IRS's budget was increased by $650 million. I think it's like $12.5 billion budget now. That has nothing to do with one audit. They audit millions of people. It's just not connected in any way to seeing President Trump's individual tax returns. And I think perhaps the easiest reason why this fails heightened scrutiny, and the most important point I want to make, is that the committee has asked for the president's audit files for audits that are still open and ongoing. If they want to understand how presidents are audited, they haven't even requested a single audit. They're not even over yet. So there's nothing that they would be able to understand about how the audit went, whether the president was treated fairly or unfairly, because they're still ongoing. And in fact, by injecting itself into ongoing audits, the committee is corrupting any usefulness of the data it would get. It is interfering with the audit now. So it can't measure how the IRS goes about this job neutrally and normally, because it's itself injecting itself into the audit process. And the committee also says, and I guess another fatal flaw with this is that the committee claims to be studying the presidential audit program, but it's requested tax returns and audit files for entities and years that are not subject to the presidential audit program. It's asked for not just President Trump's tax returns and audit files, but his businesses, which we've alleged, no one disputes, and the IRS knows better. Those businesses are not subject to the presidential audit process because they're not presidents. They have nothing to do with the stated rationale. The committee has also asked for a year before and a year after President Trump was in office. The presidential audit program doesn't apply when you're not in office. And the only explanation that they give is that, well, sometimes audits go back further to get years before someone was in office. But one, there's no evidence that these audits went back further. Two, that doesn't explain why you would go forward in the future to 2020. They're not going to go forward, they go backwards. And three, this logic doesn't have any limit. There's no evidence yet that they've gone back to further years. And so this would allow them to go back as far as they want. It's an unlimited circular form of logic that shouldn't satisfy heightened scrutiny. And even if it did, even if you thought they needed a particular audit of a particular taxpayer, which is what they say in their request, we've alleged, and no one's disputed because it's true, that the audit of the president is no different than the audit of any other person, except for the fact that the IRS has no discretion to start it. But once it starts, it proceeds as if he's any other taxpayer. So if you're worried that the IRS is overburdened by auditing wealthy people, you could get the tax returns and audits of any wealthy person, and you could study that.
I was going to ask you that since the whole protective scheme of non-disclosure of tax information is a statutory creature, couldn't Congress pass a law that just said the IRS can disclose the information, or they repeal one that says they can't? Couldn't Congress do that?
Oh, we think that law would be unconstitutional as applied to the president.
No. Just, it had nothing to do with the president. Let's forget about the president. Couldn't Congress just pass a law that says the information the IRS says is not privileged, or rather repeal the statute that says it has to be kept secret. Couldn't Congress do that?
Perhaps it could, Judge Sentelle, but I don't think that changes the answer in our case because for a few reasons. One is that the committee under heightened scrutiny has to say that's what it's doing, and it hasn't said that. And I think for good reason. Judge Mehta in the Mazars case said that kind of rationale can't possibly justify heightened scrutiny because what you're saying is that we want to get and disclose President Trump's tax returns in order to study whether tax returns should be disclosed. It's circular. You could use that to get any information from any president about anything.
Yeah.
Doesn't survive heightened scrutiny. And more importantly, besides the constitutional issue, yeah, as I said, that rationale has not been given by the committee because I think they understand the circularity problem with it. And nor would that rationale justify, for example, why are they asking for the audit files? I don't think there's anybody who's suggesting that IRS audit files ought to be published to the public. And yet the request asks for precisely that information. So if I could just continue, I'll just stick on the topic of heightened scrutiny because I do think it's the easiest place where where we've stated a plausible claim that's not subject to a motion to dismiss. One thing we've stressed is that the reason that this request is overbroad and overly burdensome is that there's no promise from the committee that our tax returns will be kept confidential or will be reviewed in camera. Instead, we've alleged plausibly that the goal here is to immediately publicly expose and release President Trump's tax returns. Mazar's opinion says the committee has to consider excessive burdens and excessive breadth. We think that type of disclosure would be excessive. And I think it's important. History speaks here too, Your Honors. There's only two compulsory process, only two times the compulsory process has been issued against a former president. And that's with former President Adams and Tyler before former President Trump. Both times the committee guaranteed that their information would stay confidential. And Mazars itself talks about a situation with President Reagan where the accommodation was reached where his information would be kept confidential. We should get the same protections.
So, so if we or the trial court ordered compliance, but no disclosure absent court order, it would pass the Mazars test?
We have other arguments, Judge Wilkins, but I think it would, I think the failure to give confidentiality fails the Mazars test. But I do think the question here is whether we've stated a plausible claim. If you believe that there's a violation of Mazars here potentially because of the lack of confidentiality, then the judgment should be motion to dismiss denied, and we should go on to the next stage of the case.
All right, any further questions? All right, Mr. Norris, we'll give you a couple minutes in reply. Mr. Letter, good morning.
Good morning, Judge Henderson and members of the court. I do want to, I have notes here on the points that my friend Mr. Norris made, and I do want to address them. I wanted to start out with a little bit of an introduction though. But first, let me introduce Stacy Fossil, who is with my office in the General Counsel, and Isabella Moore from the Ways and Means Committee. And by the way, as Mr. Norris said, he and I have been arguing about any number of things recently, and he and I just have to come up with another place that we can meet other than opposing each other in court. I suspect we could be good friends. Judge McFadden steadfastly adhered to considerable Supreme Court precedent developed over a number of decades on how to deal with, how the courts should deal with congressional investigations. And so that law is well established. And Judge McFadden wrote a absolutely splendid opinion that goes through that and applies that law. The problem here is, unlike I think probably most of what President Trump's view would be, I suspect in general, President Trump favored a limited role for the judiciary. Here, he doesn't like the test. He doesn't like what the Supreme Court has done over the decades. And so he wants this court to reject what Judge McFadden did, and this court to suddenly go into a whole different mode and actively supervise a congressional investigation. So we know the Supreme Court has said, no, that's not appropriate. Just to read one, I'll quote very briefly from Judge McFadden's opinion, which I think sums things up here, is, quote, "The problem for interveners is the low bar that the committee must clear. Even at this stage, courts should not go beyond the narrow confines of determining that a committee's inquiry may fairly be deemed within its province. It is not a court's function to invalidate a congressional investigation that serves a legislative purpose." So getting to the specifics of what Mr. Norris was saying, first he says, well, this is the wrong posture. It's a motion to dismiss. Well, easy answer to that. Both Eastland and Tenney were in motion in a dismissed posture. The Supreme Court went ahead and ruled for Congress in both of those. The Judge Sentelle asked a question about this. Mr. Norris says, he's made he and his colleagues have made allegations about what the purpose is here, what Chairman Neal's purpose is here. Well, Chairman Neal explained his purpose. He did it in an extremely formal document that Mr. Norris has. He said to the Treasury Department and the IRS, here is what I'm seeking, and here's why I'm seeking it. That's it. There it is. There is the purpose. Judge Sentelle asked, is it possible there could be, mixed or additional purposes? And of course, as Judge Sentelle, I think his question revealed, he knows, yes, there could be. But guess what? The Supreme Court has made clear on various occasions, in particular, I think it was the Wilkins case, the fact that there are additional purposes, allegations of additional purpose, they're relevant. Maybe that would be relevant in some other case, but not because of separation of powers, not how this court looks at congressional investigations. So Mr. Norris can allege, well, that's not really the purpose here, et cetera. But as Judge Wilkins' question revealed, well, what are you going to do? You're going to take a deposition of Chairman Neal? Clearly not. Can't do that. And it wouldn't, in none of these cases would the Supreme Court have stood for that. So the fact that this is at a dismissal stage and that Mr. Norris has made allegations is actually completely and totally irrelevant under the test that the Supreme Court has set down. He said, well, we must come forward with evidence. I have to admit that I'm puzzled about that. What was the formal letter to the Treasury Department, to IRS? It's not evidence. Mr. Norris says, well, there was that long meeting with the IRS. We want to know what happened there. We've made absolutely clear what happened there, and it's obvious because it's based on the law. The law is, it provides that tax return information may not be disclosed. It's a felony to disclose it unless it fits within one of the exceptions. So with the IRS, when we said we want to find out about the program, how many times has it been applied, to whom, et cetera. And the answer was, we can't tell you. It's tax return information. There's only been a limited number of presidents who've been subject to the program. And so it would reveal tax return information about them. So we cannot tell you anything about the program. Now we said, well, but you can, because under 6301 F3, you can. And they said, well, that's what's unclear. We don't know if that applies here. And so because it's tax return information, we will give you nothing. So the answer from the IRS is the same as what is before this court. 6103F, how does that apply? And so a further sit down with IRS can only be meaningful if IRS says, oh, yes, we now understand that this the exception applies, and therefore we can talk to you fully. Here's what happened in the audit of President Carter. Here's what happened in the audit of President Clinton, et cetera. But as of now, the IRS position is we cannot share that tax return information with you. So that's what happened. It was, we learned absolutely nothing of value. So it's complete frustration because of IRS's understanding of the law, which obviously Mr. Norris agrees with. So he can hardly complain that we learned nothing. And it would be very odd. It's very odd for him to say, well, go back and ask them again, maybe ask them nicer, and they'll tell you everything. Mr.
I didn't
Norris,
understand him to suggest that, Counsel.
sorry, I
Go
got
ahead.
carried away.
Go ahead.
On the GSA test, I agree. I think Mr. Norris accurately answered Judge Sentelle's question about what the test is under Mazars and GSA. But there was something that was very much wrong, which is Mr. Norris confused the burden on the presidency with the burden on former President Trump personally. And that's Judge McFadden recognized that. That's a very key point. There's no doubt that this request is for the records of a former president. And the Mazars
But
test.
when you first requested them and this constitutional controversy began, he was a sitting president.
Yeah.
That is exactly right, Judge Henderson. When then Congress, there was a turnover in Congress, and Chairman Neal issued a new request, as Judge McFadden correctly said, that superseded the prior request. And there is no doubt that at that point, Mr. Trump was no longer the president. And reading,
whether the information sought has remained the same, the controversy between the two branches has remained the same. We have a situation that involves both a sitting president and a former president. And for all we know, if this case drags out, he could be a sitting president again.
Judge Henderson, I strongly disagree. The controversy does not now involve a sitting president. The case before Judge McFadden and the case before you absolutely clearly involves a former president. And when you read the Mazars opinion, which I know very well, I mean, argue that in both this court and the Supreme Court and in the district court, the Supreme Court's opinion makes very clear that it's about the relationship between a sitting president, which is not surprising. That's what the case was about, a sitting president and a sitting Congress. And
right? Did you argue in Mazars that was decided while he was a sitting president by the Supreme Court? It came back. He's now a former president. Did you argue this dichotomy? Because it's very similar. In Mazars, they want the same information when he was sitting president as they do former president, which is the same case here.
Yes, Your Honor. And before the district court, we argued that Judge Mehta ruled that he ruled that what we'll colloquially refer to, I think he used this term too, Mazars light. And so he said that applied. And then he found that the House was entitled to actually, I think most of the information being sought. That then was appealed to the DC Circuit. I argued that case several months ago before Judges Srinivasan, Judge Rogers, and Judge Jackson. Obviously, I assume Judge Jackson will not be ruling on that case anymore. So we're awaiting a decision from that panel.
Well, what I'm
on
asking
that.
you is, did you make the same argument about recognizing that you were dealing with both a sitting president and a former president? And what, if any, difference did that make?
Yes, Your Honor.
I'm talking specifically about the separation of powers burden.
Yeah, exactly. Exactly. We made the exact same argument. We said the Mazars case, at the time we argued it on remand, did not involve a sitting president anymore. We made the exact same argument, and then we argued that, and Judge Maida, as I say, in fact, Judge Maida, I think, accepted that. He said, nevertheless, that Mazars could apply in certain ways, but it was absolutely clear that we were dealing solely with the records of a former president. And as I say, we argued that before this court several months ago and are awaiting a decision. But, and again, there is no doubt that we are only talking about the records of a former president. We have only one president at a time. Chairman Neal's request that is before this court was made after Mr. Trump was no longer the president. And by the way, the executive branch agrees. The executive branch has taken the position that it must provide the documents because there is no separation of powers or serious separation of powers argument here anymore. There is no clash between the executive and legislative branches. The president, the only president, takes that position. Now, as we know, Nixon versus GSA says that a former president may raise certain issues. Executive privilege, for example, may raise. Now, as we know, in Nixon versus GSA, the court overrode those and significantly influenced clearly by the fact that the current presidents, first it had been President Ford, who signed the legislation, then President Carter, who was defending it. So the sitting president disagreed with the former president. And here too, as I say, we are only dealing with the records of a former president. Again, there can't be any factual doubt about that. And whether he may or may not be president again, has nothing to do with the controversy before this court today.
And then you also feel, excuse me, the fact that he was a sitting president when this controversy began has no relevance. Is that what you're saying?
Absolutely, Your Honor. And we know that from as we pointed out, Mr. Norris has argued, oh, no. You look at that. You don't look at what happened after. Well, first of all, again, Judge McFadden recognized we're dealing with the current request, which superseded the prior one. But second, this court on Bonk, as I recall in, I guess with Senate Select Committee, took into account the actual facts.
Okay, I think you've acknowledged, and that raises another question. Do we know on the record why you decided to go the request route rather than the subpoena route?
Your Honor, the originally Chairman Neal issued a subpoena, and he sent a letter under 6103F. It was belt and suspenders. What
about the second one?
When the Congress changed, in the current Congress, Chairman Neal has sent the new request under 6103F. There is no pending subpoena right now. The decision was made. Chairman Neal consulted very closely with attorneys, and the decision was that we would move forward with 6103. And so this case only involves the statutory request at this point. There is no pending subpoena at this point.
Right. Does anyone have any further questions? Judge Wilkins, Judge Sentelle?
No.
All right. Thank you, Mr. Letter. Mr. Zindak.
Thank you, Your Honor, and may it please the court. Jerry Zindak, appearing on behalf of the Treasury Department. Happy to field your honor's questions. As we lay out in our brief, we believe the committee's request here is valid and meets constitutional requirements, and therefore Section 6103F required the Secretary of Treasury to comply with it. The committee's 2021 request lays out in detail both the legislative purposes underlying the request, as well as explains why the former president's records are of particular interest to the committee. Given that this is not a case involving executive privilege or documents subject to executive privilege and does not request the records of a sitting president, the committee's request satisfies constitutional requirements, and in the district court correctly affirmed the request. I think as has already been discussed and mentioned here, the allegations of improper purpose are strikingly similar to allegations the Supreme Court has heard time and again in a long line of precedent dating back to the McGrain case. And the Supreme Court has in each case concluded that provided there is an objectively valid purpose that can be discerned from the record, that these additional allegations or allegations along the lines of those made here are insufficient to vitiate a congressional inquiry. And on that score, so here again, the committee's stated purposes are objectively valid. Their interest in the presidential auto program and the IRS's conduct within that program is objectively supported by their request, and therefore, again, because we're not dealing with a case that concerns executive privilege or the documents of a sitting president, that it is sufficient to meet constitutional requirements. Again, I'm happy to answer further questions. We believe that plaintiff's other constitutional claims are also without merit, those directed at Treasury. This, as the district court found, this statute is constitutional here and certainly in the vast majority of its applications, and therefore is not facially invalid. And with respect to plaintiff's First Amendment claims, because the statute required the secretary to comply with the request, the motive in doing so is irrelevant, and plaintiff, even though we of course do not believe any improper motive can be properly attributed to the secretary here, in any event, the motive is irrelevant and the First Amendment claim fails. I'm happy to touch briefly. Judge Sentelle asked about the appropriate standard that applies here. I think in general, the framework that courts apply when approaching these types of congressional requests for executive materials is a balancing test that typically weighs the burden on the executive of disclosing the particular information at issue to Congress against congressional need for that information. And where we have cases where the documents are particularly sensitive, such as executive privilege cases, that Congress must meet a particularly high showing. The Mazars test is in many ways an application. It says when documents of a sitting president are requested, a higher showing is likewise required. Here, though, we are again talking about documents of a former president, and so therefore the separation of powers concerns are far attenuated, and presumably the showing Congress would need to make would be lesser. And here we feel that the statements that the committee has made.
Is separation of powers completely out the window when the president is no longer sitting, or is it simply applied with less rigidity? Because doesn't it seem that a president, sitting president, can be invaded in his privileges by knowing that once he goes out the door, the protection isn't there anymore? Isn't there some possibility of interference with separation of powers, even with respect to a non-sitting president, because of its potential effect on the actions of the sitting president?
Yes, Your Honor, we agree with that. And certainly if we were talking about privileged materials, there'd be even greater concerns with respect to revealing that information after a presidency, because it could affect a sitting president. But in this case, they're far attenuated. We're talking about the records of a private individual, not material subject to privilege, and they don't implicate the same separation of powers concerns that would exist in other contexts. Your Honors, I'm happy to answer any other further questions you may have.
No questions.
All right, thank you.
Thank you, Your Honor.
Forgive me for that interruption. I thought I had turned that phone off. Mr. Norris.
Thank you. A few points, Your
Well,
Honor.
wait a minute. I have a question. We have been all wound up in who the president is at the time, who's the chairman of this committee at the time, what the Treasury Department, or who's in the executive branch, including the Treasury Department and the IRS. And we've got to look at this case as executive branch versus legislative branch as institutions. And I think the language in Mazars, first of all, my question will be this. Assuming that Judge McFadden misapplied precedent, that he should have applied Mazars. When you look at what the Supreme Court said in Mazars about the fourth burden, that is the separation of powers burden, it said that burdens imposed by a congressional subpoena, and of course we have a request here, interestingly, should be carefully scrutinized, for they stem from a rival political branch that has two things going, an ongoing relationship with the president, and that's why that's no longer the case, but that's why I'm interested in the fact that he was a sitting president when this whole thing began. And then the second element is incentives to use subpoenas for institutional advantage. Now, again, we don't have a subpoena, we have the request, but that second power that the rival political branch has survives the fact that the president is now a former president. And it talks in terms of institutional advantage. That's what makes me think, we've got to look at this not as musical chairs, who's changing, who's withdrawing, who's leaving office, and so forth. So assuming we think Mazars is the right precedent, what difference, if any, will that make if it were to be remanded?
Thank you, Judge Henderson. And we do think you should at least remand, because Judge McFadden didn't say we would lose under Mazars, and a lot of his opinions suggest we might very well win under that heightened standard. And I think you've hit it right on the head. Even, the reason it's important that this request was made while President Trump is president is because everyone agrees that that original request would have had to have satisfied a rigorous version of the Mazars test, which is a heightened scrutiny test, precisely because courts should be skeptical when Congress is going after its rival. Courts are suspicious. They don't give Congress the normal deferential presumptions. They've in fact come in and act as a neutral referee. So if this was suspicious when it was issued, there's nothing about January of 2021 that eliminated the suspicious nature of the request. The request remained exactly the same. And as Judge Sentelle pointed out, there is a chilling effect even when you target a former president. Never in history has Congress ever issued this type of demand to a former president. So that lack of history ought to mean something. It suggests that Congress has long thought this is impermissible. And
one way and another, they wanted all kinds of things from the Nixon administration. They may not have had precisely this posture, but that's where the Presidential Papers Act came from, essentially, wasn't it?
Fair enough. There was a statute there at issue, Judge Sentelle. I'll say this is even more unique in that they are targeting the personal papers of President Trump, which Mazars, the Supreme Court said, is highly suspicious because they have a less evident connection to an official legislative task. And Judge Henderson, you're right that Mazars tells you have to look at the precedent that's going to be set by approving this request. And the precedent that's going to be set is that once a president leaves office, it's open season. You can get every detail of his financial life, his businesses, his private taxpayer information, which is protected by federal law. And don't worry, even if he has ongoing audits, you can interfere with them and prejudice his rights solely because he served as president. And my friends might say, there's no reason to worry about that being a big deal, but it is a big deal. It's happening here. We still have ongoing subpoenas for his accounting records, his banking records. President Trump is subject to an onslaught from this House, and they've continued to pursue it after he left office. It is a highly burdensome request that fails heightened scrutiny.
All right, if there are no questions, then thank you, gentlemen.
Thank you.
Madam Clerk, if you give us an adjournment.
This honorable court is now adjourned until Friday, March 25th at 9:30 a.m.